Good morning. Would the state announce?
Judge Zach Rogers on behalf of the state.
Good morning.
Good morning, Judge.
This is case number 18 CF 3045. We're here on an order to show cause.
Yes, Judge. Today is our return after the court granted our order to show cause as to two witnesses that had failed to show up for depositions. The state was to subpoena them to court today to present before Your Honor.
Your Honor, the state has attempted to subpoena the two witnesses unsuccessfully as of right now.
Say unsuccessfully, you just can't find them?
Well, not completely. The state has acquired information that the two witnesses are likely in Mobile, Alabama at this time. One of the state investigators acquired an address which we since discovered was not a good address. However, as of yesterday, that same investigator has acquired a new address, and I've confirmed with her that we can attempt service through the Mobile Police Department within 5 business days.
It would be our contention that these witnesses are material. They are needed, Judge. The last time we were before the court, we had discussed whether or not the court should issue an order to take into custody or give the state the benefit of subpoenaing the witnesses here. We would certainly defer to the court because we do need to get those depositions scheduled so that we can move this case to trial.
Well, were they ever subpoenaed before?
Your Honor, it's my understanding that they were.
They were subpoenaed and they didn't show.
Yes, Judge, on 2 occasions.
What is the state asking for?
Well, Judge,
I don't know all the circumstances, what their witnesses, so I mean.
I agree completely that it's problematic. They were subpoenaed twice for 2 rounds of depositions, did not show up. As to if the court is considering an order to take into custody, I would leave that to the court's discretion. What I can say is that my investigator is in the process of effecting service at this new potential address. To the extent that the court wishes to consider an alternative to an order to take into custody, perhaps it would allow the state to attempt service at this new address. And if at the next scheduled court date they still haven't shown up, perhaps an order to take into custody at that point.
We would certainly defer to the court. We understand based on case law that it's certainly within the purview of the court, but that lesser sanctions such as contempt should be processed first.
I mean, I'm certainly sympathetic. You have these are witnesses that need to be called. They're material. Based on what you're saying, I mean, I'm acknowledging that we're going to get them here one way or another. I'm okay with allowing you to subpoena them or attempt to subpoena, not subpoena, but attempt to serve the subpoena on them at this new address. If we don't come back. We'll come back at the next miscellaneous. Let's see, when's our next miscellaneous is, are we on for, pretrial is next week. Probably wouldn't be done by then.
I wouldn't think so, Your Honor.
We can come back on November 2nd. And counsel, if you will remind me that, because I'll probably forget, that I said this is our last effort and that we'll do an order to take into custody at the next one. Everybody's aware of it, so I think that's a balanced approach.
Thank you, Judge.
Okay, very good. Thank you very much.
That's all I have, Your Honor.
Okay, thank you. Have a nice day.
Your Honor, that's all from me as well. Thank you.
Yes, sir. So, Mr. Nopes, why don't we go ahead. Mariah Jernigan.
Ms. Jernigan's here. And, Judge, I've told the state that she's continuing. I think I gave last time some documents to the state showing that she's continuing in her efforts through Lakeview, and we're just simply asking today that the matter be continued.
State has no objection, Your Honor.
So we just need to continue to the next miscellaneous docket?
Fine, Judge.
Is November 2nd, November 10th?
Let's go to the next, the one out.
That's fine. November 10th, and then it goes all the way to December 1st. Well, that's PM only. We'd have to jump to December 1st.
That's fine, Judge.
Okay. We'll continue to December 1st.
At 9 a.m.?
Correct.
Okay.
Mr. Nubbs, you are a true Southerner.
Judge,
to break out your heavy coat at 45 degrees.
I had to hunt all over the house, and I went and then said, well, I wonder where it's at. And it was basically in the laundry room where I leave everything else. I looked in every closet in the house. But anyway, I found
You don't use it enough. That's good. That's a good thing.
cold this morning, Judge. I left the office, the house at 5:30
That's true. Okay, thank you very much.
Your Honor, I will tell you that Ms. Jernigan has been complying with the terms and conditions of our probation officer over in Milton, because that's where she resides now, and that she does keep in weekly contact with me.
And I appreciate that. You know, we take into account the efforts that are being made, so keep at it. Good luck. Robert Needner.
Morning, Your Honor. David Rare for Mr. Robert Needner this morning. Judge, we're here on a motion to modify pretrial release. My understanding is there is no objection from the state. Current conditions of his pretrial release are as no unsupervised contact with minor children. Mr. Needner and his wife are expecting their first child together. She's expected to be delivered on Monday, the 24th. We're asking for supervision to be modified so he can have unsupervised contact to care for his new daughter.
And Mr. Rare is correct, Your Honor. The state has no objection to that for the purposes of caring for his minor daughter. We'd asked for maybe that to be limited for about a month.
I'm sorry, what was
We'd
that?
ask for that to revert back to no unsupervised contact after, I would say, let's give it 6 weeks.
That's different than what he's asking for.
That's
What are you
also
asking for?
new to me, Judge. My understanding was the state was not objecting to modifying.
Well, that's why I like to do, when there's something filed, if you file based on a stipulated motion, you lay it out in your motion, that's one thing. But when it's filed, you can't just call my office and say, hey, the state doesn't have any agreement with it, we want it, could you sign it? This is why, so we can understand what is the state's position, because I'm very interested in the state's position. They're the ones tasked with safety of the public.
And, Your Honor, in all fairness to Mr. Rear, I went back and I looked at the file in detail overnight once I got back home, and I thought, well, I think maybe we could look at doing a shorter period of time of the non-supervised once the wife gets home, and then put it back into the non-supervised. So that was news to him. I did not,
I'm not
in all fairness to
No,
him.
and I got a call from
I'm
Ms.
not-
Basso yesterday telling me to contact the court with a stipulation that she could,
And I'm not suggesting that you were
Right.
trying to pull something over on the court.
No, and I-
If that's what came, that's not why. I'm just letting you know why I didn't just sign it.
And then that's on me, Your Honor. I went back and I reviewed it in detail and all the chats and everything involved, and I would feel more comfortable if we limited the time. But certainly I'll leave that to the court.
I'm okay with it, but, you know, we can come back and look at it in more detail, but, you know, for the time being, let's make it for 6 weeks, and if...
And if we have...
What is the date? Today is the 19th?
And if we have no issues, then, Your Honor, then we will notify the court that there have been no issues. We would have no objection to extending it. We will take that onus on us.
Why don't you just let's just do it, and then you can file whatever motion needs to be done, hopefully with agreement, and, because, you know, it's important to take both sides into consideration. I understand why you're asking for it, but I also understand the state's position with regards to, you know, safety. So we'll do it for 6 weeks. We need to have a date, unsupervised, contact with his child,
Yes, sir.
with the newborn.
With the,
Is the child born? No, unborn?
no.
When's
And
the child
Judge,
expected?
the child's expected to be born by C-section on Monday, the 24th of this month, Judge, so coming up here very soon. If the court...
24th of October, so next week.
Correct. If the court would like to hear from Kimberly Needner, now they live in Colorado at Fort Carson where he's stationed. I did ask Kimberly to be available via Zoom this morning, so I think she may be in the court's waiting room. If the court wanted to hear from her about having her husband be there for her child.
I have a waiting room. Do I have a waiting room?
I think we got,
I think we're okay right now. I mean,
Why don't we set it Why don't we do it through the end of the year, so you can go through the holidays?
I'd appreciate that, Judge.
And,
then we can revisit.
and the first of the year, if you want to extend it beyond the first of the year, then something needs to be filed. So why don't we do 2 months? Why don't we say through let's see, December, let's say through January 10th. So that'll give you time to get something.
Get it back on the docket
Get
if we
on the
need to.
docket if you want to go beyond that.
Good. Thank you, Judge.
Okay,
And I'll submit that order today, Judge.
okay. Thank you very much.
That's all I have, Your Honor.
You have a nice day. Ms. Flowers, you want to do Siegel? He's up first, so we'll do Gregory Siegel, Marty.
If I could have just one moment to speak with Mr. Siegel. And Your Honor, this is Mr. Gregory Siegel. He's signing a plea that we previously went over. I had to reprint my plea agreements this morning because I misplaced them, or didn't misplace them, forgot them. So we have an agreed upon sentence, and I can approach Your Honor with the plea and score sheet.
Okay, that'd be great. And this is 22 CF 1761. And would you announce the plea?
Yes, Your Honor. This is Gregory Siegel. We're here today in two matters. 20 CF 1629 and 22 CF 1761. Your Honor, Mr. Siegel is prepared.
What are the charges on 1629?
The charges,
They're both possession, okay.
There's, yeah, 3 counts, one of possession of controlled substance, possession of paraphernalia, and driving with license permanently revoked. And, Your Honor, he's entering a plea and pleading no contest to the charges in 2020 CF 1629. In exchange, the state has agreed to dismiss 22 CF 1761. The terms of the plea would be that he's pleading no contest. He will be adjudicated guilty as charged in 22 CF 1629, serve 7 months in jail, in the Okaloosa County Jail with credit for all time served. There'll be $515 in court costs, $100 cost of prosecution, a $150 cost of defense, and all of those monies will be due within 180 days of release, and then they'll be sent to collections.
State in agreement?
Yes, Your Honor.
Mr. Siegel, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So you heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is? And you're in agreement? I see you've signed the plea and sentencing agreement as well that contains the agreement. And have you gone over this plea agreement? Because it has some other things in it that are important, that are legal rights, affecting your legal rights. Have you gone over this plea agreement with your attorney? I want to make sure you've had all your questions answered.
Yes, sir, I understand all my rights.
Okay. Because it's important, by entering this plea, you understand you're waiving some valuable legal rights, the right to go to a trial, the right to contest witnesses, etc. Valuable legal rights, and want to make sure you're doing it freely and voluntarily. And you do understand that this is a final adjudication of your claim, of the charges against you. Do you understand that? Okay. Very good. Based upon that, the court will accept your plea. The court, in the state's null prosing, 22 CF 1761 is a part of this?
Yes, Your Honor.
Okay. And so in 2020 CF 1629, there'll be an adjudication of guilt, 7 months in the county jail with credit for time served. The standard court cost of prosecution, the money will be paid 180 days of release from jail. And if not, it'll go to collections after that. Okay? And is the defense in agreement regarding the
The score sheet?
score sheet?
Yes, Your Honor.
Okay. Very good. Thank you very much. We've got one more, Ms. Flowers, that doesn't have an attorney, so let me
Okay,
get
sure.
that one, and then we'll do the rest of yours. You can just leave your stuff if you want. Goodman, Ernest Goodman, is he here?
He's in custody, Your Honor, I
Oh,
believe.
he's in custody.
Your Honor, he has violation of probation on 20 CF 2967, violation of probation on 21 CF 971. He also has a new law case in which he has the public defender, which is 22 CF 2601.
Okay, all I've got is one on my docket here, 21 CF 971. What is the other VOP?
20 CF 2967.
2967. And is the public defender been appointed on 2967? Because on the one I have, 971, I had to ask him if he wants an attorney appointed. Are you on the other one? I'll ask.
So, no. We only have the new law right now, which we'll be withdrawing from, but.
Okay. Okay, so, Mr. Goodman, first order of business, there's a new law charge, you've been appointed an attorney. That has triggered 2 violations of probation, okay? You have a right to an attorney in those 2 cases as well. So do you want to have an attorney appointed? Yes. So the court will appoint the public defender, and what I'm going to do, because you haven't had a chance to talk to your attorney, is to go ahead and enter a denial on your behalf. That preserves all of your rights. You can talk to your attorney and kind of figure out where you're going with all this.
Thank you, sir.
Okay? So, counsel?
I was just going to tell him real quick.
Okay, go ahead.
Okay.
So he'll enter a denial on both the cases, Madam Clerk.
And a new court date, Your Honor.
New court date would be November 2nd. Is that too soon?
That's fine, Your Honor.
So November 2nd, or do you want to track them all together with the new law charge? That'd probably be better, wouldn't it? Sure. So you want the 2 VOPs on the miscellaneous docket, or run them all together on the pretrial? Okay. So when is the new charge, when's the next court date, Madam
I
Clerk?
don't think he's actually been to, I guess, arraignment.
Is that today? Is it?
Plea day is November 10th.
Okay, so why don't we just run them all, well, let's put it on November 10th. We'll put these 2 as well. So we'll just run them all together. Okay. So, remainder with regional conflict cases, so you got Corporal Letty, Ms. Flowers.
His new law, the offers are 60 days jail and 11 probation. I just didn't know
Yeah, I got 11 from 29 county jail.
Jennifer Flowers on behalf of Robert Caporaletti?
Yes, ma'am.
Okay, and 2020 CF 449, this is a VOP. I believe the offer from the state at this time is 1129 in jail. So we would enter a denial today and set it for the next
The next miscellaneous is November 2nd.
November 2nd. Let's put it on November 2nd then.
Very good. So, or court will enter denial, and we'll come back on November 2nd for another, figure out where we're going.
Sounds good.
Lucas Davison.
Good morning. Morning. Your Honor, this is Lucas Davison. We're here today on a motion for bond reduction. As I stated, it's 22 CF 1733. As I stated in the motion, he He has a current pending new law charge in Bay County as well as a VOP in Bay County, which the underlying charges are these, this grand theft auto
Sorry, say
charge.
that again, the underlying,
The underlying charge for the VOP in Bay County, he was on probation in Bay County. He got arrested here in Okaloosa County for a grand theft auto charge. I believe he has a defense, but he's expressed that, and I've actually been in contact with the public defender's office over in Bay County. He's expressed that he wants to work out some sort of global plea to both cases, but because he hasn't been served on the VOP, the public defender can't really help him yet, so I'm in Bay. So I'm asking basically not for him not to be released, but for the court to convert his, because he's unable to post the $5,000 bond that he currently has. I'm asking for the court to change that bond to a signature bond so that he can.
what's the charges in Bay County?
It's a VOP and
What are
another
the underlying charges?
grand theft auto.
So this is a second grand theft auto?
Yes, Your Honor. It's not just a simple, it's kind of a situation where the car was borrowed. There is evidence, that.
We don't have to get into
And we don't have
that
to,
stuff.
exactly, but I just, basically what it would do if he was able to sign himself out or sign a signature bond, it would trigger. I've called also the sheriff's office over in Bay County to see if they would just come and serve him on the warrant so that the public defender could be appointed and we could work together and resolve these cases, because I'm unable to really advise him on the merits of this case if it's going to be a basis for a violation over there. So basically, he wouldn't be getting out, it would just trigger, he has a VOP hold, so he would just be transferred to Bay County and be able to work out the charges over there, and then hopefully do some sort of concerted plea.
Rivers?
Your Honor, the state would ask that the bond remain the same. I mean, from what she's saying, he's on probation over there for grand theft, and now he has another grand theft.
Well, we're only
Or
asking.
grand theft auto.
Well, he has a current bond of $5,000 cash for professional, and he can't post it. He doesn't have the money to post it, so we're just asking for it to be converted to a signature. If he is able to sign himself out, he's not going to be let go. He has a VOP hold. He's going to be transported to Bay County. The offer here is a withhold and probation, Your Honor, and he has expressed that he would be willing to, work with that offer, but I am unable to, without being able to see what all the allegations are of the VOP. If he pleads out to this charge here, it could be used as a plea, the plea could be used against him on the VOP over there. So I'm just basically asking that the court allow him to be transported to Bay County.
What's his bond over there?
He has a no bond on the VOP.
Court will change it to a signature bond. They'll hold, and he's on a hold over there. Russell McLaughlin.
One moment, Your Honor. Okay, Your Honor, Mr. McLaughlin we've previously gone over this plea agreement. We have a plea agreement that worked out with the state, and we've previously gone on over it, and he signed it, but he's having to sign a new copy this morning. May I approach, Your Honor?
Okay. Thank you.
Your Honor, this is Mr. Russell McLaughlin. We're here this morning on 2022 CF 2165 and 2022 CF 628. Your Honor, Mr. McLaughlin is going to withdraw his previously entered plea of not guilty and enter a plea of no contest to the following. In 22 CF 2165, he would be adjudicated guilty, 90 days in the Okaloosa County Jail with credit for time served, 515 court costs, $100 cost of prosecution, $150 cost of defense. In 22 CF 268, he'll have a concurrent sentence, adjudicate guilty, 90 days, serve 90 days in the Okaloosa County Jail concurrent, 515 court costs, $100 cost of prosecution, and $100 cost of defense. All the outstanding fees and costs would be paid within 180 days and then to collections.
Is that 180 days from today or 180 days from his release from jail?
We'll do it from his release, if that would be.
Can you just make that note? Is the state in agreement with that?
Yes, Your Honor.
Mr. McLaughlin, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
So,
And the defense is in agreement on the score sheet?
Yes, Your Honor.
So, Mr. McLaughlin, you heard your attorney state the terms of your plea agreement, and I see that that same plea agreement has been reduced to writing, and it looks like your signature's on this, so are you in agreement, and have you gone over this plea and sentencing agreement with your attorney to make sure you understand all the legal issues? Because you're waiving some valuable rights by entering into this plea, the right to go to a trial, the right to contest it, the right to confront witnesses. Those are all important rights that you have that you're waiving by entering into that plea. Have you gone over all this with your attorney? Make sure you understand it.
yes, sir.
You had all your legal questions answered? And you understand that by entering this plea, this is a final adjudication, this is a resolution of this case? You're not going to come back anymore, do you understand that? And you've gone and got all your questions answered from your attorney. Very good. Based upon that testimony, the court will accept your plea agreement. The court will sentence you on both counts, both charges, to 90 days in the county jail. Let me just ask you this. On 2165, you've got, it's a little bit unclear, so I think I understand it. There's a possession, there's a paraphernalia. Paraphernalia, we got to divide them up. It's not just 90 days. So would the paraphernalia be credit for time served? Okay. Okay. So I just want to make sure that that's clear on this. So on you've got two possession charges and then one paraphernalia charge, okay? On the two possession charges, you're being sentenced to 90 days in the county jail, serve concurrent at the same time. So a 90-day sentence, credit for time served. In addition, you got a paraphernalia, possession of paraphernalia. We're just giving you credit for time served on that, so you don't have any more on that one. So you're really just spending time. Your jail sentence is on the two possession charges. You understand that? Okay. So that's what the court is ordering, and there will be an adjudication of guilt on all three of these charges. Very good. Any questions, sir? Would you just put that, make sure that's clear on that? Okay. That's good. Very good. Yeah, that's all right. Okay, thank you very much, sir. You're good.
You're good. Hopefully you'll get out soon.
Zaki Moore.
All right, Your Honor, I have a plea and sentencing agreement, if I may.
Okay, very good. Thank you.
Your Honor, this is Mr. Zaki Deshaun Moore. We're here today in case number 22 CF 1189. Mr. Moore is prepared to withdraw his previously entered plea of not guilty and enter a plea of no contest to count 2 and count 4 as charged. The state will be null prosing count 1, burglary of a conveyance with assault or battery. That is being null prosed, and count 3, tampering with a witness. Those are being null prosed by the state. And count 2, the agreed upon sentence would be an adjudication of guilt, 6 months Okaloosa County Jail, followed by 24 months of community control, followed by 1 year of standard probation, for a total of 3 years supervision. $667 in court costs, a $100 cost of prosecution, a $150 cost of defense. He is to complete the batterer's intervention program, complete a mental health eval and follow any recommended treatment, complete a substance abuse eval and any recommended treatment. He's not to consume any alcohol or controlled substances without a prescription, and he is to have no contact with the victim unless and until the victim submits in writing that she wants contact. I believe, it's my understanding in my talks with the alleged victim that she has done that with the state, but can the state confirm? I might have
Just go ahead and continue the announcement, and then
Okay,
we'll
sure.
confirm
And-
everything with the state. And
and
then
count-
as to count 4,
As to count 4, that would be the criminal mischief charge, which is a misdemeanor. It would be an adjudication of guilt and credit for time served.
on the first, on count 2, the 6 months in the county jail, credit for time served,
Yes, of course, Your Honor.
you need to put that in here. That's an important one. I don't think that's in here.
Yes, Your Honor.
Okay. State, is the state in agreement, and can you
That's-
share about the victim and what's going on with that? Has the
That-
victim been in contact, et cetera?
Count 1 and count 3 has been null pros, Count 2 and 4, he's pleading to. That is the agreement. I've looked in this file, and I don't see anything about a victim has requested.
Well, let me just say this, has the victim been consulted on or been informed about what this is? That's what I wanted to make sure. That's number 1.
Oh, there is something in here, let me see. Yes, Your Honor, there is a statement here from the victim. The victim has been consulted.
Okay.
But Ms. Glisson still wants it in writing to probation,
Oh, to probate, okay.
saying that
Oh.
she's still okay with that.
Okay, I'll instruct.
It's writing that she wants, again, just to be clear, put it down there, into probation.
Probation, okay.
Yeah. Okay. So, Mr. Moore, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes? Okay. Speaking to that mic for me, sorry, because we're actually recording this.
Yes, sir.
So, I just want to make sure you understand the terms of your plea agreement and that you're entering into it freely and voluntarily. So you heard the attorney state the terms of the plea agreement. Obviously, importantly, 2 very serious charges are being dismissed, null prost, right? The burglary and the tampering with a witness. The 2 charges you're being charged with, there'll be an adjudication of guilt on the felony battery, 6 months in the county jail. You will get credit for all time served. That'll be followed by 2 years, 24 months of community control, followed by 1 year of standard probation. So that's 3 years in addition to the 6 months county jail sentence, right? You said total supervision was 3 years, so it's technically, it's 6 months plus the 3 years, right? I
That
just
is
want to make
correct.
sure we're clear. I don't want him to, I thought this,
The intention is for him to have 3 years of supervision upon release from Okaloosa County
very good.
Jail.
That's what I thought too. I just want to make sure the record is clear. Okay. And in addition to that, there's importantly the batter's intervention, mental health evaluation, and following any treatment. That's an important part of this because obviously you don't want to be back here again, right? So as to the second charge, not the second count 4, which is the second charge you're pleading to here today, that will be an adjudication of guilt. That's on the criminal mischief, credit for time served. So is that your understanding what the plea agreement is? And have you gone over, I see you've signed the plea and sentencing agreement. Have you gone over this with your attorney? Make sure you had all your legal questions answered. Because you're waiving some valuable legal rights. Right to go to a trial, confront witnesses, limiting your right to an appeal. All those things are important legal rights. You need to make sure you've gone over it with your attorney, you've had all your questions answered.
Sir.
Okay. And you do understand that by entering into this plea agreement, you are waiving the right to go to a trial and that this will be a final adjudication of your case.
Sir.
Do you have any other question regarding this plea agreement? Okay. Based upon that, the court will accept the plea agreement. The score sheet, the defense okay with?
Yes, Your Honor.
Okay. So again, based upon that, the court will accept the plea agreement. The court will sentence the defendant to 6 months in the county jail. He will get credit for time served, followed by 24 months of community control, followed by a year regular probation, and in addition, the other requirements that are contained in the plea agreement. Any questions? Okay, thank you.
Your Honor, we request the supervision fees be waived.
Thank you very much. Yes, sir.
And does the court have any preference on which one of these counseling programs, whether it be the batter's intervention, the mental health, or the substance abuse, needs to be done first?
You told me in order to try and move it as efficiently as possible, you had made, explain to me, give me your input on that.
I think we should, are you asking
I'm
me?
yeah, I'm asking.
Your Honor, based on the facts, as Ms. Glisson had conveyed them to me, I believe that she would ask for mental health evaluation to be
I mean,
first.
that's what makes sense to me, but I'm open to suggestions. You know, I want to do what's best so we can have a successful outcome. So
I will
I think
second that, and we will certainly advise Bridgeway or wherever he chooses to go of the same, and tell him that we need to do that first, and then that will probably roll into the batter's intervention, because of course that's the longest
Right.
treatment program that we have.
Okay, I think that'd be the best. Thank you for inquiring about that. Bobby Simmons.
Mr. Simmons.
I'm sorry, turn right here.
Yes, ma'am.
Your Honor, may I approach?
You may. Thank you.
Your Honor, this is Bobby Wayne Simmons. We're here today in 22 CF 2187 and 22 CF 2132. Your Honor,
Give me those case numbers again.
22 CF 2187, 22 CF 2132.
Okay, that's right. I'm sorry. I heard it. I thought it might have been a mistake. Go ahead.
Thank you. Yes, Mr. Simmons is ready to enter a plea. He's going to withdraw his previously entered plea of not guilty and enter a plea of no contest as charged in both cases. In 22 CF 2187 on count 1, the agreed upon sentence would be an adjudication of guilt. He'll be given credit for time served and 12 months of probation, $515 in court costs, $100 cost of prosecution, and $150 cost of defense. He'll need to do a substance abuse evaluation and any recommended treatment, no alcohol or controlled substances without a prescription, and 15 hours of community service. Count 2 would be an adjudication of guilt, and he would be given credit for time served. In 22 CF 2132, he would plead no contest. The agreed upon sentence is an adjudication of guilt with credit for time served, given credit for time served, concurrent with 22 CF 2187, and serve a concurrent 12 months of probation with 22 CF 2187, $515 in court costs, a $100 cost of prosecution, $150 cost of defense. And on the plea agreement, it includes a substance evaluation and treatment no alcohol, and 15 hours of community service, but it is our understanding and agreement that that would be concurrent with 22 CF 2187. Count 2 would be an adjudication of guilt, and he would be given credit for time served.
And waiver of cost of supervision on
Yes, sir.
both, on the probation. Very good. Is the state in agreement?
Yes, Your Honor.
Mr. Simmons, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Heard your attorney state the terms of the plea agreement. Is that your understanding what the plea agreement is? I see that you've signed a plea and sentencing written agreement that contains the same plea agreement. Up. Got to get it signed.
Oh, he didn't, yes.
It's all right. That's why I try and look at them. That's all right.
That's just saying you agree to everything. You just want to, I know. Right here.
Mr. Simmons, even though you just signed your plea and sentencing agreement, have you gone over this plea and sentencing agreement with your attorney? And
Yes, sir.
make sure you understand kind of the legal, had all your legal questions answered? Because
Yes,
there's
sir.
more stuff on here than just the terms.
Yes, sir.
And you understand that you're waiving the right to go to a trial, you're waiving some valuable legal rights by entering into this plea. You believe it's in your best interest to enter into this? And you understand that there'll be 12 months probation for each charge, each of the 2 possession charges. They'll be served concurrently. You will get credit for all time served. Counts 2 in both, the trespass and the possession of paraphernalia, will be an adjudication of guilt. You just get credit for time served, so you don't have to do anything further on those. The other 2, you have the 12 months probation, and you also, importantly, maybe most importantly, do the substance abuse evaluation, see if you can get on top of that, because we don't want, I'm sure you don't want to be back here. We don't want you back
I
here.
sure don't want to be back.
And we don't want you. Sincerely, we don't. So take it seriously and work this thing. Court will accept your plea agreement and sentencing as contained in the plea and sentencing agreement. Okay, good luck. Brittany Renee Way.
Your Honor, this is Brittany Renee Way and 22 CF 2257. Your Honor, we're here today on a motion for bond reduction. As I stated in the motion, she was arrested on August 22nd, 2022, charged with making a false report and tampering with evidence. The pretrial services recommended a signature bond at first appearances, but the judge made it $5,000 cash or professional per count for a total of $10,000 cash or professional. Your Honor, she can't afford this bond. She has 3 minor children, and in having this high of a bond is equating her to having no bond. She's lived in Okaloosa County over 20 years, has strong ties to the community. She's not alleged to have committed any offense involving violence. As stated in the in the motion, I stated the rule governing, what should be considered in
My
bail
report
determination.
we have a plea agreement, so I need to
Oh,
pull
yeah.
and that's all right, I just need to pull the motion up, because I didn't look at it. Normally I would. Hold on just a second. Hold on just a second.
I'll address that.
I didn't ask him.
Your Honor, we're respectfully requesting the court modify her current bond to a signature. I'm currently, and I know we're not here today on a motion to dismiss, but I am currently preparing a motion to dismiss for the count one, the tampering charge. I know the court, the two things the court wants to consider is her risk of flight and her danger to the community. Like I said, she has been in the area for 20 years. She has represented to me that she has a permanent address, that she would come to court, and she is, of course, not alleged to have committed any act of violence, nor is there's any facts indicating that she would be a danger to the alleged victim listed. Also, there's a no contact order, and we're requesting that that be amended to no violent contact. The alleged victim is not really, she's basically, and I know we're not here to argue the facts of the case, but she's basically charged with changing her story to the state, changing a statement that she made to the state regarding the father of her 3 children, which are triplets, and some location of some evidence. But it's there, and again, I know we're not here on a motion to dismiss. But I am asking that the court to consider my argument that there is, great holes in the state's case, especially when it comes to the tampering charge, as well as the other things, her having the strong ties to the community, her having the 3 minor children, and no violence, and considering changing her bond from the very high $10,000 cash professional that she just absolutely cannot make, to convert it to signatures, so that she can make bond and address these charges.
Your Honor, the state would object to any modification. The statement that she wrote that was sworn to indicates that this same person that she's asking to have contact with, that lives with her, that she indicates that he beat me, threatened my life, put a gun to my head, told me if I ran, call the cops, he would kill me. He sells meth. He will not let me leave. And it goes on and on. There's a mention of children. The defense is mentioning children. The state is concerned for the children as well. We believe that based on the nature of the allegations and then what she does later in changing her story, we believe that $10,000, $5,000 per count, a cash professional is appropriate. She does have a prior criminal history, and the state believes that it should remain the same as what the initial judge said at first appearance.
There are victims that change their stories all the time for various reasons that aren't charged the way that Ms. Way has been charged in this situation. She's essentially being held in Okaloosa County Jail on a bond that she can't post because she's the victim that changed her story for whatever reason that may be. All the things that Ms. Rivers just discussed, those are things that she alleged against another person. She did not commit those acts. So it would just be my plea to the court to have to consider changing her bond to the signature so that she can post it.
Allow her to post $5,000 signature bonds. However, the court's not going to change the no contact at this point.
And Your Honor, who's that no contact with?
Mr. Mobley,
Okay.
I believe. Mobley.
And in addition, I do believe she's got a no bond warrant out of Walton County for violation of supervision.
I was not aware of.
She does. I have a copy of it in my file. I know that.
I
signed it.
don't doubt you. Is the state aware of that?
No, Your Honor.
If the court wants, she was on supervision. I was supervising her over here for Walton County. When she got arrested for this new charge, we submitted the violation report to Walton County advising that she got a new arrest. Judge Wells signed a warrant with no bond. I don't know if she's been served on it yet. I do know that he signed it.
And I actually did know about this, and I have put in a call to Walton County because these charges actually occurred before, like, it wouldn't actually be a violation of her when I looked into it. The allegations happened before she went on probation, is what I'm
not disagreeing whether I researched it before I submitted the violation report, and I submitted the violation report.
Okay. Okay. That.
She was, and this may help, Ms. Flowers, she was on probation. She violated with a misdemeanor cutting the fence, a felony criminal mischief. The court in Walton County chose to modify that supervision and place her on community control. When she committed this offense, she was on that probation.
That's my understanding.
No, she wasn't on the community control portion, but she was on probation. And it's modified, it never stopped. She was on 3 years probation. That probation never stopped. It got modified during that period and she got community control, but she was still on. That helps you.
Okay. Well, so you have to deal with the violation of probation over there.
And they'll, if you give her the bond, our sheriff's
They'll pick
office
her
will
up.
contact them and
They'll
Walton County
hold.
can figure it out.
Okay, very good.
Thank you, Your Honor. Thank you.
That's all you got, I
That'll be-
think. Okay, thank you. You have a nice day. Okay, Wendy Boardman.
Casey Etheridge for Wendy Boardman. And Your Honor, this is a fairly new violation of probation case. There are several allegations. I would be asking to set this for the December 1st date. I believe there's some things I need to look into before we decide how we're going to pursue this case.
You're entering a denial?
Yes, Your Honor.
So we'll enter a denial, we'll come back on December 1st.
Thank you.
Stephen Bullard.
Not today. We can't do it today anyway. Okay. We'll talk about it when I come out there.
Okay.
Casey Etheridge for Stephen Bullard, and we're here in 2020 CF 2839. And for today, we'd be entering a denial and asking to set this one for December 1st as well.
Very good. We'll deny and come back on December 1st, 9 a.m. Foster Caps.
Casey Etheridge for Mr. Capps, and Your Honor, this is here. We're here in 2020 CF 3092. We'd be entering a denial for today, and we would ask to set this for November 2nd. I believe we'll be able to come to a resolution that day.
Okay. Court will enter a denial, and we'll come back November 2nd. Next is Landon Carter.
Casey Etheridge for Mr. Carter, and we're here in 2020 CF 1749, 2022 CF 2208, and 2022 CF 2242. And he would like to withdraw his previously entered plea of not guilty and enter a plea of no contest and accept the state's offer. And it would be in 2020 CF 1749. It would be adjudication of guilt, 18 months of probation, cost supervision waived, $515 in court costs, $100 cost of prosecution, $150 in public defender fees, a substance abuse evaluation, and any recommended treatment, no possession or consumption of alcohol or controlled substances without a prescription. Count 2, adjudication of guilt, credit for time served. And then in 2022 CF 2208, it would be adjudication of guilt, 18 months of probation concurrent with 2020 CF 1749, cost supervision waived, $415 in court costs, $100 cost of prosecution, $100 in public defender fees, 24 hours of community service work, no contact with Cynthia Jean Minette, restitution to Cynthia Jean Minette in the amount of $472.82. And then in 22 CF 2242, it would be for count 1, adjudication of guilt, 18 months of probation concurrent with 2020 CF 1749, cost supervision waived, $515 in court costs, $100 cost of prosecution, $100 in public defender fees, and count 2, adjudication of guilt, credit for time served.
Aid and agreement. Defense in agreement as to the score sheet.
Yes, Your Honor.
Mr. Carter, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of your plea agreement. Is that your understanding of the plea agreement, or are you in agreement? And I see that you just signed the plea and sentencing agreement that also contains the plea agreement. Did you go over this with your attorney? Make sure you had all your legal questions answered, because the plea and sentencing agreement contains quite a bit more than just the agreement. So you understand that by entering into this plea agreement, you're waiving the right to go to a trial, you're waiving some valuable legal rights, essentially. This will be a final adjudication of guilt. You believe it's in your best interest to enter into this plea, waive those rights? Do you have any questions concerning these? You had all your legal questions answered? Okay. Very good. Based upon that testimony, the court will accept your plea agreement as stated. As to the 2 counts of possession of a controlled substance in 1749 and 2242, there'll be an adjudication of guilt, 18 months of probation, cost of supervision will be waived, but those will be served concurrent at the same time. There are a number of costs and that are contained in this. You'll have to pay those during the term of the probation. you do have substance abuse evaluation and follow through with the treatment. That's a condition of the probation. You understand that? Okay. And the rest of the charges, there'll be an adjudication of guilt. You get credit for time served. So those are resolved. Any other questions concerning these? Okay. Very good. Thank you very much.
And Your Honor, that's no contact with the victim?
Yes, no contact, yes.
Okay. Amy Crenshaw.
Casey Etheridge for Amy Crenshaw, and we're here in 2022 CF 2164. And Your Honor, we did file a motion to withdraw the capias in this case. However, we do have a plea agreement. I don't know if the court would like to, if we could withdraw the motion and enter a plea, if that's amendable to the court.
Okay.
Okay. She would like to enter a plea of no contest, accept the state's offer. For count 1, it would be adjudication of guilt, credit for time served. And count 2 would be adjudication of guilt, 18 months of probation, cost supervision waived, $415 in court costs, $100 cost of prosecution, $150 in public defender fees, no possession or consumption of alcohol or controlled substances without a prescription, and a substance abuse evaluation and any recommended treatment. May I approach?
You may. State
That is the state's offer, Your Honor.
in the capias,
The state has no objection to the court withdrawing the capias.
court will withdraw the capias. And so, Ms. Crenshaw, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, I do.
And you heard your attorney state the terms of your plea agreement. Is that your understanding of what the plea agreement is, and are you in agreement? Okay, and I see that the same plea agreement is in the plea and sentencing written agreement, and looking on the back page, I see you've signed it. So have you gone over this plea agreement with your attorney, make sure you had all your questions answered as it relates to this plea agreement? You understand that by entering this, you're waiving some valuable legal rights, the right to go to a trial, to confront witnesses, to have the state prove their case. You understand all that? And have you had all your other legal questions answered?
Yes, sir.
You understand this is the final adjudication of your case? It'll be finally resolved. Okay. Very good. Based upon that testimony, the court will accept your plea agreement. The court will, there'll be an adjudication of guilt on both charges. As to the possession of paraphernalia, you'll get credit for time served. The tampering charge, you'll get 18 months probation. Cost of supervision will be waived. Fees and costs will be paid during the term of the probation. And obviously, importantly, the substance abuse evaluation and follow the treatment. That's a condition of your probation. You understand that?
Yes, sir.
Okay. Any questions? Okay. Thank you very much. Yes, ma'am. Oh, you were just hanging around just because you enjoyed the proceedings. Okay, I think we're passing on Dillingham
Yes, Your Honor.
till later. Sean Donnelly.
Casey Etheridge for Sean Donnelly, and he would like to, we're here in 2022 CF 2471. He would like to enter a plea of no contest and accept the state's offer. Count 1 would be null prost, and he would be pleading to count 2, adjudication withheld, credit for time served, $270 in court costs, $100 cost of prosecution, $150 in public defender fees, and he'd have 180 days to pay or be reduced to judgment.
State in agreement?
Yes, Your Honor.
Okay, Mr. Donnelly, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You understand that what your attorney just said, is that your understanding of what the plea agreement is? I see you've signed the plea and sentencing agreement. Did you go over it with your attorney, make sure you had all your legal questions answered? You're entering into this freely and voluntarily? And you understand that by entering into this, you're waiving some valuable legal rights, the right to go to a trial and contest it. This will be a final adjudication. Okay, any other questions concerning this? Okay. Based upon that testimony, the court will accept your plea agreement, and there'll be a null pros on the possession of a controlled substance charge, and as to the possession of paraphernalia, an adjudication will be withheld, credit for time served, court costs and fees payable in 180 days or reduced to judgment. Thank you. Joseph Gainey.
Casey Etheridge for Joseph Gainey. We're here in 2018 CF 408. And Your Honor, I believe there's some, I guess, debate as to what we're going to do about this. I don't know what.
Your Honor, previously when
Debate? Okay.
Well, previously when we were here, there was 3 cases that was brought before the court. 2 were violations that DOC had filed. The other one was a VOP for this particular case, which is 18 CF 408. It's my
What's the DOC file? What were they?
Those were violations of conditional release. It's my understanding that DOC has elected not to go forward on those violations of conditional release. That's something that we don't ever handle. That is handled administratively by DOC.
Okay.
And then in this particular case, he is on probation after he gets out of jail. However, this is not, it's my understanding, this isn't a violation of his probation. So,
It's not?
correct. So my understanding is probation does not want to go forward with the violation of probation. I don't believe one's even been filed. So probation and the state is asking for Mr. Gainey to be released. He will report to probation, back to probation, normal terms and conditions.
Correct? Probation?
We brought in the hired guns right here. This is Mr. Wilkinson, Your Honor.
Wilkinson, thank you for gracing us with your...
Yes, Your Honor. If
You
I
may.
might explain very quickly.
Please, thank you. If you want to come up to the podium, you're welcome to.
Yes, sir. Your Honor, the Okaloosa County Sheriff's Department arrested Mr. Gainey for violation of probation in 3 separate cases. And as Ms. Rivers has pointed out, he was only on probation in one of those cases, and that was 2018-408. The other 2 cases, which are 2018-1032 and 2018-2919, he is on conditional release under the jurisdiction of the Florida Commission for Offender Review. And at this point, the court has no jurisdiction for those 2 cases. Now, the specific condition of supervision that the Sheriff's Department charged Mr. Gainey with violating was violating his curfew. Mr. Gainey had a curfew imposed by F-Corps, but he did not have a curfew imposed by the court in 2018-408. Therefore, it is probation's position that it is not a violation of his probation in 2018-408. And to further clarify, Your Honor, the violation, which is a violation of the conditions of conditional release, has been reported to F-Corps, and F-Corps has declined to take action.
So we have no current VOP case in 18 CF 408?
No, sir, Your Honor, and I have taken the liberty of preparing an order for your signature, which would dismiss the violation as a result of the arrest. I believe it would close the loop on this incident.
Counsel? Yeah.
No objection.
Okay.
If I
You
may approach?
may approach. Thank you. Appreciate you providing that clarification to the court.
Yes, sir. And I
Okay.
apologize for any confusion.
No, it's all right. I'm sure that the defendant will appreciate clarifying it so he can get out. So based upon the order dismissing the violation of probation, you are, you'll be immediately released.
Sir, thank you.
Thank you.
Thank you, ma'am.
Mr. Gainey, I believe I'm going to have to work out the conditional release violation with the jail, but that should not be any problem.
Now, he's still on probation, right?
Yeah.
Okay, so before you leave, just check in over at the table, because you want to make sure that you get all that straight so you get moving in the right direction.
Thanks, sir.
Thank you. Okay. Tell you what, why don't we, it's 10:25, let's take a mid-morning break for about 10 minutes, then we'll come back and go. I just want to make sure we have the Zoom link. I'll talk to Eileen about, did she provide the Zoom link? Is it on?
874, and he would like to admit to the allegations in the affidavit and accept the state's offer of adjudication of guilt, revoke and terminate probation, 270 days in county jail with credit for all time served, including the additional 35 days waiting for extradition from Alabama. And he has a $100 cost of prosecution, $150 in public defender fees, and all fees, fines, and court costs will be reduced to judgment.
State in agreement.
Yes, Your Honor.
May I approach?
Thank you. Mr. Harrington, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Do.
You heard your attorney state the terms of your plea agreement,
Yes, sir.
and I see that those same terms are contained in the plea and sentencing agreement that you signed. Is that your understanding of what the plea agreement is, and
Yes,
are
sir.
you in agreement? Have you gone over this plea agreement with your attorney? Make sure you had all your legal questions answered.
Yes, sir.
Importantly, you're waiving some valuable legal rights by entering into this, waiving the right to a trial, confront witnesses, have the state prove their case. All those things are very important. You're waiving those to enter into a plea.
Yes, sir.
Do you believe that's in your best interest?
Yes, sir.
Okay. Do you have any other questions concerning the plea agreement for your attorney? Okay. Based upon that testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on the single count, revoke and terminate probation, sentenced to 270 days in the county jail with credit for all time served, including the additional 35 days waiting for extradition from Alabama. The fees and costs would be reduced to judgment. Okay? And the defense okay with the score sheet?
No objection.
Thank you. Matthew Hughes.
Casey Etheridge for Matthew Hughes, and we're here in 2021 CF 2763. Mr. Hughes would like to, enter a, admit to the allegations in the affidavit and accept the state's offer for count 1 and count 2, the 2 misdemeanors. It would be adjudication withheld, revoke and terminate probation on those counts, 90 days in county jail with credit from arrest for violation of probation from 9/20 to 2022 only. And then on count 3, it would be adjudication withheld and reinstate probation to the original terms and conditions of the felony count, the cost of supervision waived, and an additional mental health evaluation and any recommended treatment, an additional $100 cost of prosecution, and an additional $150 in public defender fees.
State in agreement?
Yes, Your Honor, that is the state's offer.
Yep.
Hughes, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay, so I'm a little unclear about your plea agreement because you were revoking and terminating on 2 counts with 90 days in the county jail with credit for time served, but then you're reinstating probation on a 3rd charge.
Yes,
Would
Your Honor.
that start at the end of the 90 days with credit for time served
It should, yes, Your
in
Honor.
the jail? Is that what you're
Yes.
intending to do?
Yes. We need.
Just want to make sure this is worded right. Reinstate probation. Counsel? You see, I just want to make sure that it's worded correctly.
Your Honor, is the first 2 misdemeanors?
Yes.
Okay. So the two misdemeanors were revoking and terminating.
Correct.
And he's being placed on or reinstated to felony probation on what would be count.
But the 2 that are revoke and terminate, that he's serving 90 days in the county jail, I just want to make sure, I'm assuming that probation starts at the end of the county jail sentence, but I just want to make sure that's clarified. That's your understanding of how it
That's
should
my
be.
understanding of what Ms. Etheridge just said.
That's my
Okay.
understanding. As long as that's, I mean, is that okay with probation? Is that how?
And can I look at something, Your Honor? Oh,
Sure.
Ms. Galogly is. I'm just making sure that he got probation on those misdemeanor counts. Because a lot of times they just get time served. I can't remember on Mr. Hughes.
Yes, he got 1129
Okay.
on both of them. So
Okay.
they're just
We
revoking
got it.
those
That's good.
in 36 months.
Okay.
We're working hard on Mr. Hughes, and he continues to mess up, though, Your Honor. I don't know what more I can do for him, but we'll try.
Okay. So, did I swear you in? I swore you in.
Yes, sir.
So you heard your attorney state with the clarification, so on the 2, the resisting arrest and the violation of the injunction, withhold of adjudication, revoke and terminate probation, 90 days in the county jail with credit for all time served. Those 2 were served, they're concurrent, they're served at the same time, they're not on top of one another.
Yes, sir.
In addition, at the end of the county jail sentence, there'll be an adjudication withheld and reinstate probation on the resisting officer with violence, that underlying charge, along with, completing a mental health eval and just following any treatment. Okay? Is that your understanding of what the plea agreement is?
Yes, sir.
You understand that by entering into this, you're waiving the right to go to a trial, this will be a final adjudication. Do you understand all that? Somewhat?
You have a question?
Okay. Well, I just want to, do you have any questions concerning how this is?
No, ma'am, no, sir. I'll just go to it and then 90 days and I'll be able to get out with,
With probation. It'll be get credit for time served. I don't even know what that is, but, I don't know how long you've been in. So, 90 days, county jail with credit for time for violent probation on 9/20. I guess that's what the credit for time served is, correct?
Yes, Your Honor.
Okay, it'll run from that point. Okay, very good. Based upon that, and your defense is okay with the score sheet?
Yes, Your Honor.
Okay, based upon that, the court will accept the plea agreement and 90 days in jail concurrent with credit for time served, and then reinstate probation on the resisting officer with the additional mental health eval, okay? And cost and fees.
And Your Honor, from probation standpoint, in lieu of his probation being reinstated after the 90 days, can we just reinstate him now? And he'll be in jail. This is the guy who sat in jail waiting on Keaton one time, and Keaton couldn't put him in. He wound up having to do 4 months in jail on what we classified as dead time. I think Ms. Rivers remembers that.
Ms. Rivers, I'm looking for a little input from you. You're hiding back there.
Your Honor, the state has no objection to the probation starting today or
Okay,
from
just
the...
reinstate today.
Yeah, I mean, it doesn't say it's afterwards.
It doesn't say, but we clarified, so let's put it in writing and clarify it. Okay, so we'll start the probation from today. So you get credit while you're in jail. That was my question when I was asking how to, it wasn't.
So we're just reinstating him. Okay.
Any other questions? Okay, good luck.
And we will certainly refer him for the mental health evaluation immediately.
Okay, you're good. Thank you.
We need to talk to them, huh?
You want to do Hinton? Do we have Hinton up? I skipped over that one. I didn't see it on the other one. Is that Staley too? Which one?
Cook.
Yeah, Randolph Cook.
Okay, we'll do Cook next. You want to do Hinton? Whoever, either one of those two. Whoever's up closest.
Casey Etheridge for Ms. Hinton. And Your Honor, this is
Give us
a
the case
case...
number.
I'm sorry.
Especially because...
So we don't have the files anymore, Your Honor. Just give me 1 second, because we're withdrawing.
She's before
22
the court.
CF 1983.
Yes, and then
And before the court on 22 CF 1982.
there's a case this morning, and then a case at 1:30. If we could handle them both, I would appreciate it.
1982 is the one this afternoon.
Yes.
Okay, I see that.
Okay, and Your Honor, there was a motion to withdraw and an order sent in this case. I don't believe it's been signed that I saw, but it's based on a conflict that's come up, arose from this case. And so we were here for a bond hearing, but unfortunately I can't proceed.
Even if you filed the motion, even if
Right.
it hasn't been signed.
Right,
you
so I still can't, yeah.
What's the status of that? Have we signed the new? It's not been signed. Okay, so it'll go to the regional conflict, right? Okay.
No. So you're going to get Ms. Jennifer.
Okay, so we'll put this on the next docket on November 2nd. She should be signed by that time. And there's a motion for a bond. It's in the file, right? So we can just put that on that. In the plea this afternoon on 1982, we'll go ahead and enter a not guilty plea just to preserve her rights.
Thank you, Your
You
Honor.
don't have to come back this afternoon. We'll come back on November 2nd. You'll be assigned the Regional Conflict Council, so hopefully we can get the motion for the bond dealt with at that time. Okay?
And I'll ask when. So there is a... What did you set it for, Your Honor? I apologize, I didn't hear you.
November 2nd,
November 2nd.
9 a.m. And Randolph Cook is next.
Casey Etheridge for Randolph Cook, and we're here in 2020 CF 1166. Mr. Cook would like to enter a plea of no contest and accept the state's offer. Okay, I'll add that real quick. I'm going to accept the state's offer, and so count 1 is a lesser included offense of misdemeanor assault, a credit for time served. Count 2 is a lesser included offense of misdemeanor trespass, credit for time served. And count 3 is as charged, and it's 11 months, 29 days of probation, no alcohol or drugs during probation, no contact with the victim, a substance abuse evaluation, and any recommended treatment. The cost of supervision will be waived. It would be $270 in court costs, $100 cost of defense, and $100 cost of prosecution. And then there would be $262.55 in restitution for prisoner transport to the Okaloosa County Sheriff's Office. Thank you. That's fine, as long as you say it's yours.
Right.
You may. Okay, Mr. Cook, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
You heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is, and are you in agreement?
Yes, sir.
I see that you've signed the last page here of the plea and sentencing agreement that contains that language. Have you gone over this plea agreement with your attorney? Make sure you had all your legal questions answered?
Oh, yes, sir. It's a year probation, correct?
Yes. 11
It
months,
is a-
29 days.
11 months, 29 days of probation, so 1 day short of a year.
Okay, yes,
Okay.
sir.
That's the primary. The other 2 charges will be credit for time served, so the 3rd charge, the resisting arrest without violence. In addition, however, it's important that there'll be no contact with the victim. You understand that?
Yes, sir.
Who is the victim in this case?
Renee Howard.
And there's also a substance abuse evaluation. That's also a condition of the probation, so you've got to follow through with that or you'll be in violation of the probation. You understand that?
Yes, sir.
You understand that by entering into this plea, you're waiving the right to go to a trial and to have the state prove their case, and this will be a final adjudication of your case. Do you understand that?
Yes, sir.
And you feel that it's in your best interest to enter into this plea and waive those rights?
Yes, sir.
Okay. Very good. Based upon that, the court will accept the plea agreement. There'll be an adjudication of guilt on all counts, count 1 and 2, lesser included offense of misdemeanor assault and misdemeanor trespass. You get credit for time served. Count 3, the resisting arrest without violence as charged, 1129 probation. And then the other, the no alcohol, substance abuse evaluation, et cetera, along with cost and fees that, including the one cost to the Sheriff's Department for transportation. Those will all be payable during the course of your probation. You understand that?
Yes, sir.
Very good. Thank you.
I have one more question.
Javier, if I pronounce that right, Jackson. Hey, Javier.
Not at all. Yeah. Okay.
And then you'll come to us, okay?
Casey Etheridge for Mr. Jackson. We're here in sorry, this is okay, 2012 CF 596, 2012 CF 599, and 2012 CF 624. May I have one moment, Your Honor?
May.
Mr. Jackson would like to admit to the allegations in the affidavit and accept the state's offer. In all three cases, it would be revoke and, or adjudication of guilt, revoke and terminate probation, 11 months,
What?
29, sorry.
Okay, sorry.
11
We
months.
announced the case numbers?
I did, Your Honor, but I'll say it again. A 2012 CF 596, 2012 CF 599, and 2012 CF 624.
Okay. Go ahead, I'm sorry.
Yeah, you're fine. Adjudication of guilt, revoke and terminate probation, 11 months, 29 days in county jail, with credit for all time served, $100 cost of prosecution, $150 in public defender fees, all fees, fines, and court costs reduced to judgment. And it's concurrent on all cases and all counts.
Hey,
That's correct, Your Honor. And this is a legitimate, uncoerced plea.
downward departure.
Yes, Your Honor.
You may. Thank you.
Your Honor, I just want to put on the record, in case the court is, I guess, probably questioning why this case is so old. He was serving a sentence out of Walton County in state prison and did not get transported back here to handle the VOPs back then. And so that's why we're here with this today.
Thank you for that explanation. Mr. Jackson, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? You heard your attorney state the terms of the plea agreement. It's basically 1129 with credit for time served. There'll be no further probation beyond that, fees and costs. All these will be, all three of the cases will be concurrent. They'll all be served at the same time. So I see you've signed the plea and sentencing agreement that contains this as well. Have you been able to make sure you had all your legal questions answered by your attorney?
Yes, sir.
You understand this is the final adjudication of your case? And you're waiving the right to go to a trial to contest all this? You
Yes, sir.
understand all that? Do you have any further questions of your attorney as it relates to this plea?
Oh, sir, that'll be it.
Okay, very good. Based upon that, the court will accept your plea agreement, revoke and terminate probation on all three of the cases. Will be an adjudication of guilt on each of the charges. 1129 county jail for all the cases. Credit for time served will be, of course, accorded, along with fees and costs that will go to judgment. All are concurrent. That's important, obviously.
Your Honor, if I could briefly readdress Mr. Cook.
Sure.
That's 20 CF 1166.
Yes, sir.
He got 1129 of probation. He just advised us that he lives in Valdosta, Georgia. That will not require a transfer of supervision, but we are requesting that he mails in his report while he's up there. And in addition, with that new interstate rule, he may have to pay the $100. I'm not sure of that, but I just want the court to understand that he may be required to pay it before he leaves here.
Okay. Does
Okay.
do you understand that, sir?
Yeah, that'll be $100 before I leave.
Yeah, well, it might.
Might. I
It's
just
not-
want the court to understand, we're going to address that when we get back to the office to see if
Okay.
he's going to have to.
I just want to make sure he understands it and is in agreement with it. Okay? Very good.
Thank you.
Okay, thank you. Appreciate it, Mr. Berry. Okay, I think that wraps you up, Sethridge?
Yes, Your Honor. Well, except for Mr. Dillingham, Your Honor.
Okay.
Yes.
Mr. Oglesby.
Your Honor, this is Mr. William Oglesby, present before the court in 21 CF 802 for VOP arraignment. Tim Gibbs representing Mr. Oglesby this morning. He does have a new law in 22 CF 2516 that's currently set for November 10th for plea day. We'd like to enter denial on this VOP and track this with that new law on November 10th.
Very good. The court will enter a denial on behalf of the defendant, and we'll schedule it for November 10th to track with the other cases.
Thank you, Your Honor.
Okay, thank you. Georgia Seiler.
Your Honor, this is Ms. Georgia Seiler, present before the court, 21 CF 1191, violation of probation arraignment. If I can have just one moment. Your Honor, for today, we'd like to enter denial, and if we could leave this on November 2nd.
But what do they hold?
Very good. We'll come back on November 2nd, 9 a.m.
Second or seventh, Your Honor?
Second, did I say second, number 2, November 2. Next is David Stanley. Want to do that one? We can do that one next.
Your Honor, this is Mr. David Stanley, present before the court, 22 CF 2376. Tim Gibbs on behalf of Mr. Stanley. On this case, Your Honor, we are set for a bond hearing this morning. He has been incarcerated on this failure to appear since July 29th of this year. He does have another case, Your Honor, 2020 CF 2243. It's an underlying DUI charge. He currently does not have a bond on the failure to appear. He's not being held on the underlying DUI charge at this time. I believe he's already posted that bond, so we're not here on that case. He has lived in this area for life, Your Honor. He would be living in Defuniak Springs. He is self-employed with his own landscaping company that's based out of Defuniak Springs as well. He's a high school graduate, has a master's in liberal arts. There were 2 previous failures to appear in the 2020 case. The first one was in February. That warrant was recalled. However, there was a...
Say that again?
So there were 2 failures to appear, 2 capiases issued in the DUI case. The first one was in February of this year. That one was recalled. He was reset for April for pretrial. The capias was issued again there. He indicates that the reason that he missed in April was because he actually also had to report in Walton County that morning to probation. He is on probation in Walton County. He has resolved the case there and would be on probation in Walton County if he is released. He also, I believe, is still on pretrial supervision here in this county if he were released. We're asking the court to set an ROR, a signature bond, or reasonable cash professional bond on this failure to appear.
Ms. Rivers?
Your Honor, on 20 CF 2243, he does have multiple failures to appear. On this new law, the failure to appear was charged because due to the serious nature of the prior charge and the fact that there was 3 months after the first to the second failure to appear. And the state believes that based on the facts that the court should not give him an ROR bond.
What are the charges
On his first case?
on both cases?
Your Honor,
One's a
on
DUI, what's the other?
20 CF 2243. We've got a 4th DUI and driving while license suspended. The new law case is the failure to appear. He's asking the court to ROR on a failure to appear when the facts indicate he failed to appear twice, and based on the statements that was made, he failed to appear because he chose to go to a different place. He chose to go to Walton County. There's a consistent pattern here, and the state believes that it's appropriate that a bond be set and honored, that the bond set be honored in this matter. And so if it's a no bond, then the state asks that it remain a no bond. But based on his history, it seems inappropriate to change to an ROR bond because we'll just be right back here with another failure to appear.
Your Honor, he does live locally. As I indicated, he does work locally. He owns his own landscaping business. He would be living locally. If the court's not inclined to set an ROR signature, we would ask for a reasonable cash or professional bond for him to be able to make.
Court's going to issue a $1,500 cash or professional bond.
Very well, thank you, Your Honor. Here.
William Taylor.
Your Honor, this is Mr. William Taylor, present before the court in 20 CF 1695, 21 CF 1055. Both of these are violations of probation. If I may have one moment for him to sign a written plea. I just need you to sign right there, please, and put today's dates. Today's date, please. Today's date.
What's today's date? Been cleaning everything.
It's 19th. Your Honor, if I may approach.
Thank you. You announce the plea.
Your Honor, Mr. Stanley is admitting the violation of probation this morning. The agreement with the state is that he would be reinstated to the original terms and conditions as well as termination date that is he's currently serving on probation. His probation would be modified to make the next 12 months community control sanctions. Also, during his reinstated supervision, there would be imposed the $200 cost of prosecution. That's $100 for each case. Total $250 public defender fee. Any other court costs that are required to be imposed by statute. He would also be required to enter a substance abuse evaluation within 30 days of his release and enter a treatment, if recommended, within 60 days of release.
Very good. Mr. Taylor, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? Okay. State in agreement with this?
Yes, Your Honor.
So, Mr. Taylor, you heard your attorney state the terms of the plea agreement. Is that your understanding of what the plea agreement is, and are you in agreement? I see you've signed the plea and sentencing agreement Importantly, in this case, obviously, you're going to have the same reinstating probation, so it'll be the same term of probation, but the next 12 months are community control, higher degree of supervision. It's kind of like house arrest. I like that better because that's a clear description of what community control is. Are you willing to do that? We want you to be successful. We don't want to have you come back in here and get caught up in this again. But so I want to ask you, are you thought about it? You committed to doing this?
Yes, sir. I believe with more structure, I'd do better.
Okay.
That was also reflected in Officer Conley's recommendation on his violation report.
Okay. Okay. And importantly, the substance abuse evaluation and then follow up the recommended treatment. Got to get on that because sometimes it takes a few weeks. So you'll be able to get this done. So you obviously have thought about this and gone over it closely with your attorney, got all your legal questions answered. You understand you're waiving the right to go to a trial and contest all this. This is a final adjudication of your case. You understand all that?
Yes, sir.
Any other questions that you have of this? Okay. Based upon that, the court will accept your plea agreement, and as to both cases, we'll reinstate probation to the original terms and conditions and terminate, except with the following modification. Modify to the next 12 months of your probation will be on community control, then the fees and costs, and then the substance abuse evaluation within 30 days of release and recommended treatment within 60 days. Okay?
Thank you, Your Honor.
And you don't have a score sheet?
I don't know if the state had prepared one as of yet.
Your Honor, there's not one as of yet.
Do we need one on this?
We'll file one when she gets back.
Okay, very good. Thank you.
Thank you, Your Honor. I believe that concludes my business. Okay. Thank you, Your Honor.
Gibbs? McKenzie? You want to do McKenzie first?
Yes, sir, please.
Joshua McKenzie.
Charles Russell, Public Defender's Office. Judge, this is Joshua McKenzie. Case number is 20 CF 2881. Mr. McKenzie is an add-on. He's here for a VOP arraignment. At this time, we're going to enter a denial and ask the court to reset this for November the 2nd at 9 o'clock.
Very good. The court will enter the denial and we'll come back November 2nd at 9 o'clock. Dylan Martin? Dylan?
I think it's Dylan, Judge.
Dylan. How's the back feeling, counsel?
Oh, a lot better. I think it's just old age, Judge.
I get you.
If I can have a second. Judge, on this case, we've reached an agreement with the state in exchange for admission of the violation of probation. There's going to be an adjudication of guilt, revoke and terminate his probation, 210 days in the county jail with credit for any time served, pay $100 cost of prosecution, $150 public defender fee, and he would have 180 days after his release to either pay or the money would go to judgment. May I approach?
Score sheet, Ms. Rivers.
Yeah, I have to, Your Honor, the state will be filing a score sheet on this matter.
And is the state in agreement on the plea?
Yes, Your Honor.
Okay. Mr. Martin, would you raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. So, let me just clarify, there's 4 counts originally. I see only 1 count here. Is the other 3 null prost?
The other 3 were misdemeanors, Judge, and it was time served.
Okay.
He only had probation on the possession of controlled substance.
Okay, so those have already been dealt with. We don't have to address those?
Correct, Judge.
Okay. Just wanted to make sure. So we're here on a violation of probation on just one remaining charge, the possession of a controlled substance. And for that, you've agreed that there'll be an adjudication of guilt in 210 days in the county jail. Is that your understanding? And fees and costs go to collections. No more revoke and terminate probation. That means that'll be finished. Do you understand that?
Yes, sir.
Is that your understanding of what the plea agreement is? And have you gone over this with your attorney? Make sure that you understand kind of what this all means
Yes, sir.
legally?
Yes, sir.
Waiving the right to go to a trial. This will be a final adjudication of your case. Do you understand that?
Yes, sir.
You believe it's in your best interest to enter into this plea?
Yes, sir.
And you're satisfied with the representation of your counsel?
Yes, sir.
Very good. Based upon that, the court will accept your plea. There'll be an adjudication of guilt on this possession charge, 210 days in the county jail, with credit for all time served. Fees and costs, you have 180 days after release, or it goes to judgment. Probation, the remainder of probation revoked and terminated. Okay?
Okay.
Very good. Thank you very much. Daniel Whitted.
Charles Russell, Public Defender's Office. Judge, this is Daniel Whitted. Case number is 21 CF 3051. On Mr. Whitted's case, we are currently getting him screened for rehab programs. So at this time, we would ask that the case be continued till November 10th at 9 o'clock to give us time to get those results back and see if there's a way we can resolve this case.
Very good. We'll continue it until November 10th, 9 a.m.
Thank you, Judge.
Thank you. Oh, it's only PM, so it'll be, can we do it in the afternoon? I mean, I don't know how many we've got. I don't know if we need to have some lengthy ones. Are we going to be able to resolve it by the 2nd? It'd be better if we did it on the 2nd.
We can try, Judge. I just don't know if we can get the screening back that quickly.
Seems unlikely.
We'll do 10.
Screening done by the 2nd.
We'll do it on the 10th. That's fine.
Okay.
November 10th, it's in the afternoon, though, 2 p.m.
2 p.m.? Okay. Thank you, Judge. That's all my cases.
Okay. Thank you. All right. Okay, let's see if we can pull up Mr. Dillingham. Marnie, can you help me out here?
Oh, he's right there, too.
Judge Ketchum.
Over there, too.
That's scary.
The frustrating part, though.
Can you, can somebody call the jail? They're not.
So, like, these are extra.
They're not in yet.
And,
We go ahead and announce the case.
Yes, we're hearing from Michael Dillingham, 2022 CF 2294. We're here for a competency, I guess, hearing, and there's an agreement based on the reports that Mr. Dillingham should be sent to the state hospital for competency restoration training.
Okay. Have you been in communication with him? Does he understand what's going on?
No. I mean, he does not understand what's going on, so.
You just announce it. And do we need to, do we have any sense for when he can be, whether they have a bed, or is that?
I mean, unfortunately, he'll just be added to the list at this point. I know that there's some other
You know,
people.
What's the, what we should probably do is come back in what, 3 months? If you, make sure he's been picked up.
Yes, Your Honor, that's,
Say a month.
yeah.
Okay.
I mean, I know that the jail has a heavy interest in getting him.
Will that speed it up any?
I believe so.
I believe it can. They've indicated they will facilitate any paperwork
I'd
necessary.
like to know that, if they can speed it up somehow.
Yeah, I know, right?
We have never been able to.
Yeah. Probably what they've done is already done the paperwork and just waiting on us.
That's what they said.
Well,
Yeah.
But it's not up to them or us.
Right.
It's the hospital when they have the availability.
Yeah.
What's that?
They are. They're willing.
So that might facilitate it. Right, just have a bed.
It's interesting to see, you know, your video, your picture like blowing up so much.
Interesting is one way to put it. During COVID, we would have 50 to 100 hearings a week, all on Zoom.
Mm-hmm.
I'd have to, you know, it's weird looking at yourself every day, you know, I mean, like
Yeah.
all day long with like, it's like looking in, like conducting trial with a mirror.
Mm-hmm. I thought the docket days were interesting because you'd have like, you know, especially the out of custody and then like the in custody. I mean, it looks like just huge, you know, like Hollywood Squares, like all these attorneys, and it was crazy.
Is that how you all did it? You all did them all and brought them all in at one time?
Yeah, we had the out of custody one day and then the in custody the other day.
We had some hearings that were massive, that had, you know, 18, 20 people in them.
Mm-hmm. Okay.
Well, let me ask you this, is it required for him to, for him to hear it from the court, seeing that he is not really capable of receiving that information because he's got competency issues? I want to follow the proper rule, but I want to keep everybody safe and not unduly have to have him transported with jail staff and whatnot. I'll do whatever. I'm not going to push it. I'm just wondering.
I'm
Ask
just
the question.
concerned. I mean, yes, he's not going to object to it, I don't believe, but I believe that
He needs to be.
it's required that he be able to hear it at
Fair
least.
I know as a general rule that is the case. Would counsel approach real quick on another matter? Hey, Mr. Dillingham, okay, the state go ahead and announce the case.
I heard this. Who's the punching DA?
It's 22
Who's the punching DA, boy?
22 CF 2.
What do you work for, Ketchup?
So, we're here on a competency hearing. There's been agreement between the state and the defense. What defense want to announce?
Yeah, sure. The defense and state agree that at this time, Mr. Michael Dillingham is not competent to proceed and that he needs to undergo some competency training, and that Dr. Stephen Zeman wrote a report and suggested that he may be able to regain competency within 6 to 9 months. So.
Okay. State's in agreement.
Yes, Your Honor, and we are asking that he be committed to the Florida State Hospital
Court
for
will,
treatment.
court will find him to be incompetent to proceed and commit him to the state hospital with competency training. Do we have to put a time? We'll come back in a month to make sure he's gotten over there, and at that point, we'll set up review dates. Defense, anything?
We're just asking, Your Honor, that we're stipulating to the admittance of Dr. Stephen Zeman's report.
Very
And if
good.
it hasn't been filed, we'll make sure it gets filed.
Okay, very good. Anything else from the state?
No, Your Honor.
Okay, very good. Okay, thank you. Thank you, Mr. Dillingham. Appreciate your help. Thank you all, gentlemen.
Thank you, thank you. All right.
And what was that date? Did we get a date? Okay. And Your Honor, what was the date for status? I apologize.
30 days approximately. Let's see. We'll come back on, December 1.
Okay.
We'll figure out where we're going. Okay. Very good. So our 1 o'clock we already pled that, so we'll, unusually small plea docket. So we'll come back at 2 o'clock for just a couple of hearings. I think the private defense for the afternoon hearing, I'm the only, so I think you all are excused.
Thank you, Your Honor.
Okay, you all have a nice day.
Two.
You too.
Okay. We'll reconvene at 2 rather than 1:30.